Yeah.
Good afternoon, everyone. Welcome to the Appellate Division First Department. We have oral arguments for today, October 4. According to this, there are 5 hours of argument requested. So as you know, please, only request the time that you actually believe that you need and not the time that you actually want. Please keep in mind that we have read your briefs. We are familiar with the facts of the case, and we will proceed accordingly. As you know, you must keep your mask on while you're in the courtroom. Once you begin your oral arguments and you're actually arguing, you may remove your mask at that time. First case on for argument, People v. Jean Alboa Aka. That matter is submitted. Adams versus Nycha. Submitted. Carey versus Chantel. Submitted. Finkelstein versus U.S. Bank.
Yes, Your Honor. You're responding to U.S. Bank 7-3, please. Or Appellant.
Yes, respondent?
For respondent, 15 minutes, please, Your Honor.
I'm sorry?
1, 5, 15.
Okay, so that's 7. 7 and 3 and 7. Campbell versus New York City Department of Education. Appellant? Are you the respondent? Would you like to submit? Yes. Submitted. Thank you very much. People versus Troy Falk. Submitted. Young versus 1530 Rosedale Partners. 3 minutes. Do you want any rebuttal? Yes?
Respondent, 5 minutes.
Okay, so let's do 4 and 2 and 4. Cologne versus Teachers Retirement. Okay, so that's 6 and 2 and 6. National Community versus Micro Office. Four and 1 and 4. People v. James Dixon is submitted. Rosenthal versus Roosevelt Island. And who are you? Which respondent are you? Okay, so that's 7 and 2, 5 and 4. Thank you.
We previously discussed if you could allocate this 7 and 2 to the state for Roosevelt Island. 7 minutes for the state respondents and 2 minutes for Roosevelt Island.
So what did I just say?
5 and 4.
So that would be what it would be. You want to break that up differently?
Yes, you are.
Okay. So you just wanted, I'm sorry, so you wanted 7 and 2?
Yes.
And 5 and 4 gives you 9? So you want less time, right?
No more time. So 7 minutes for the state respondents and 2 minutes for the others.
Right, but that's too much time.
So I think both are 9 minutes, Your Honor.
Okay. So 7 and 2, and then what did you, 7, and then you want 7 and 2 as well?
Just
7 and 2 for the appellant. Okay. Respondents, what is it that you want?
7 minutes for the state respondents and 2 minutes for Roosevelt Island.
Right. And so what I said was for the state respondents, you get 5, and then for Roosevelt Island, I'll give you 3. Okay? Finished. Pizarro versus Lake Street fee. Respondent?
Respondent, Your Honor, 6 minutes.
4 and 2 and 4. Santos versus Manadoc Construction.
Appellate, 4 and 2, please.
4, 2 and 4. Sinai versus Luna Park Housing. Is that you as well? Sir? No. Sinai versus Luna Park Housing. That matter is submitted. Flynn versus Red Apple is submitted. Montgomery versus 215 Christie is submitted. First case up for argument is Finkelstein versus U.S. Bank.
Good afternoon, Your Honors, and may it please the Court, Michael Marcucci for U.S. Bank. This is an odd posture for an appellate argument to have two decisions from this Court in the last
Yes,
month.
we are fully familiar with that fact.
And so I'd like to start with where I think the IKB panel went astray in the application of the Court of Appeals jurisprudence in RMBS cases. We now have a series of RMBS decisions from the Court of Appeals interpreting largely the repurchase protocol of the standard RMBS PSA. But I think there's two principles that have emerged.
You know, before you get to that, I think the strongest argument IKB may have, and it's this idea that if the Western-Southern approach is adopted, then aren't there circumstances where there's really no one to enforce the repurchase protocol? So why don't you start there?
I'll start there. And the answer to that is no. That in most contracts do not identify an enforcing party. And we don't conclude as a result of the absence of an identified enforcing party that the promises are unenforceable. And what's happened in the RMBS PSAs is the trustee has negotiated for an allocation, a limited liability based on limited duties on an extensive several-page discussion limiting the trustee's duties. The backstop to all of this for the certificate holders who want the trustee to do more or want other actions to be taken is to direct the trustee to do that. So in that same Article 8 that limits the trustee's liabilities and reflects that negotiated allocation of liabilities, it also empowers certificate holders to direct the trustee. And the certificate holders bought into these PSAs, they bought into these investments, recognizing those limitations and recognizing the restrictions on their rights that were imposed, but they do have that right to direct either with a sufficient threshold of certificate holders, with indemnity to the trustee, or both, depending on the provision.
I think that one of the issues that the panels disagreed upon was this language of agrees to, and what should that mean in the context of these trusts and what the trustee is obligated to do. How should we be viewing those?
So I think you have to view the trustee's obligation in Section 2.06 in light of the allocation of liability in Article 8. And what in Article 8 says is what the trustee has negotiated for is that it's only liable and responsible for any duties that are specific and expressly set forth in the contract.
And in fact, that's what the case law says, right, in terms of these contracts.
Yes, Your Honor, that the duties are negotiated narrowly, and that in the RMBS context, the contracts mean what they say.
Counsel, you also say that agrees to is language of commitment. You concede that in your brief, do you not?
Yes, it is, and the question is a commitment to what?
So, but does that concession undercut your argument that you can't be liable for failing to exercise a mere contractual right because it's the trustee's discretion to exercise that right? So aren't those two in contrast with each other, in contradiction with each other?
They are not, because the plaintiffs here are alleging that we breached an obligation to enforce. They have a specific view of what we were specifically required to do to enforce these obligations. And there's nothing in the contract that expressly and specifically sets forth what it means to enforce.
Right, and so the plaintiffs are arguing that if it's not the trustee's obligation to enforce, then there is no remedy.
No, the remedy would be either for the trustee to act on its own discretion, or for the certificate holders, if they're concerned about the issue, to direct the trustee to conduct an investigation and then take any additional enforcement enforcement efforts, right?
Right, so the failure, quote-unquote, failure of the trustee to act to enforce does not leave them without a remedy.
It does not. And in most of the RMBS cases that have come before this court and before the Court of Appeals, it was certificate holders having directed the trustee to take action with respect to those putbacks, regardless of whether those contracts specifically required the trustee to enforce or not. Because the holders could take that action, it was within the rights of the trustee to do that. It just wasn't an obligation of the trustee to do it outside of a direction, and without that specific and express instruction within the PSA.
So what do you make of the language? These trusts are interesting because some of the trusts specifically state that the trustee shall enforce the obligations, the repurchase obligations. Others don't. What's to be made of the language? Are these sophisticated parties that are deciding what the rights and obligations are of different trusts, and is that, should we be guided by that?
So in the first instance, yes, right? These are obviously sophisticated parties, and contrary to the approach the motion court took, which was to put the burden on the party arguing for the plain construction of the contract to prove that the parties actually intended it, the baseline rule in New York is that if you have a very long, very detailed contract, you start from the premise that the parties intended to say what they say in that contract. And so I think you'd probably have to go back deep into the history of trusts as to why some have it and some don't, because obviously one of the main purposes of that whole article is to create a true sale of the mortgage loans from the sponsor to the trustee, and a lot of the language in Article 2 is trying to get at that point, that the trustee is now the owner of the mortgage loans. It's not on the books of the sponsor anymore, and it's not on the trustee's books, right? Everything it has.
So is that a negotiated term, I guess is a question, where some trusts have it, others don't?
I think we have, whether it's specifically negotiated on each one, I don't know. I mean, I think at some point in the past, the parties decided to include that or not include that based on various considerations. There's nothing in the record about these particular PSAs and whether those were specifically included here.
That's what I did not understand. You know, well, you don't know this, but I had sat as surrogate, acting surrogate here in New York for a couple of years. And that, you know, when I saw a trust and it had that language, I was assuming that that was the bargain for the agreed upon language. And that was what the parties wished to occur.
And I think that's true here too. I don't think there's any reason to doubt that the parties negotiated at some point this language and decided to include that for whatever reason they did. I just can't point to something in the record saying that in these specific PSAs, but I think given that there is a variety of terms, and we can look to similar agreements to see what's included and what's not, that is the kind of term that would be negotiated at some point, and the parties would make a conscious decision to include it or not to.
Or not include it.
Thank you.
Thank you.
Good afternoon. May it please the court. John Lundeen from Lundeen PLC for plaintiff respondent. I think a good place to start is some of the responses to the questions that the court had for appellant. There was talk about these terms being negotiated, but of course, these terms weren't negotiated with the certificate holders. The certificate holders are third-party beneficiaries, and so where they stand in relation to this document is somewhat
But why does that matter? The duties of the trustees, I think everyone would agree, is defined by and limited by the terms of the various PSAs, correct?
Certainly, Your Honor. They're defined by the terms of the PSA.
But not just defined, but limited. It's duties specifically set forth, correct?
Not if I understand, Your Honor. The PSA, and the Court of Appeals has said this, a PSA is interpreted according to basic contract law. If you look, for example, at the Court of Appeals' recent decision, U.S. Bank v. DLJ, they looked at a PSA that was silent as to exactly whether notice to an obligor must be loan by loan or collective.
But in this instance, we're talking about pre-event defaults, and in that, the case law is specific in that instance that the trustee's duties are limited to those specifically set forth in the PSA. So we can't necessarily read additional duties that aren't specifically inside those PSAs, because that is not what the case law supports.
Well, no, but Your Honor, there is a difference, we think, between implying duties that aren't in the contract and interpreting the contract. And again, if we go back to U.S. Bank v. DLJ, they were merely interpreting a contract. And this is so many of the Court of Appeals decisions that we cite, where even though a contract doesn't say a specific thing interpreting the contract, the court determined that there was duty there. U.S. Bank v. DLJ.
If I'm to accept that argument, aren't you asking me to rewrite the contract in accordance with terms, for example, imposing a putback duty when there is no explicit duty in some of the trusts?
No, Your Honor, we're saying that the court should interpret the contract as the Court of Appeals did in U.S. Bank v. DLJ. For example, there, the court recognized there was no explicit explanation of the detail to be given, but it said, for example, let's look at the structure. There's only 90 days to respond to a putback demand. Logically, that must mean the demand has to be loan by loan. It looked at the calculation of the cure right, and the calculation it said was loan by loan. Well, it's only reasonable to think then that the obligation to give notice was loan by loan. There's nothing in that PSA that says loan by loan. The Court of Appeals interpreted the contract, which is all we're asking the court to do.
But except in this instance, there's limiting language. And it seems to me that what you're asking us to do is to essentially write out of the contract the limiting language, the specifically set forth provisions of Section 8 of the PSA.
Well, no, Your Honor. First, there's only 3 trusts where there isn't explicit language providing a duty on the trustee. So
isn't that significant in itself, that some trusts have it and other trusts don't have it, so one could make the argument that, in fact, in some instances, the trustee agreed to have a putback obligation, and in other instances, there was no agreement?
if we're speaking with respect to the 3 trusts where the language isn't there, Your Honor, I understand that argument. On the other hand, I think the IKB court has it right because you have to look at the whole structure of the argument. The trustee receives the loans in trust. The trustee is required to identify deficient mortgage files, and the trustee is required to demand that they be cured, as the IKB court and the court below found. Any sensible reading of the agreement, not importing agreements, but simply interpretation of the contract the way the Court of Appeals has done it, must mean that the trustee, if the trustee has to make a demand for cure, it really seems sort of obvious, and I think any reasonable person, any reasonable investor, for example, reading the PSA would expect that the trustee then was going to do something about it after it made this demand that it was required to make. It makes no sense.
But why would you make that, come to that conclusion given the language of the trust, in terms of the limiting language of the trust?
Well, the limiting language, if you're talking about the no implied obligations, language like that, Your Honor, we discussed that in length in our papers, and I think that that language, which appears in different forms in each PSA, says no more than when there's an event of default, you have implied duties because you have the duties of a common law trustee. Before an event of default, you have merely contractual duties. And we agree with that. We're not saying that there are extra contractual duties with respect to this. We're saying that an interpretation of the contractual duties, even for the 3 trusts, which there's only 3 that don't have this language, even an interpretation of the contract with respect to those duties, the only reasonable interpretation is that the trustee, once it makes the demand that it is contractually required to make, must do something when the obligor.
Counsel, speaking of
ignores the
contractual
demand.
language, though, there's 2 trusts that require prior written notice to the trustee
And it seems to me that your argument does not adhere to the language of the contract with respect to those two trusts.
No, our argument was.
You're saying that they had knowledge from various other sources, but there's no written notice that you can cite concerning those two trusts.
In our complaint, Your Honor, we do not allege on such and such a date you received a letter giving you notice. That's true, but we allege extensive notice, all of which they would have received.
From whom?
In writing, and
You're talking about, I'm sorry to interrupt you, so you're talking about other lawsuits, the events that transpired to bring down the real estate market? Is that what you're referring to?
yes, Your Honor.
But weren't those kinds of arguments, and you can argue that it's maybe distinguishable, were rejected by the Court of Appeals in DLJ?
Oh, no, not at all, Your Honor. The DLJ decision had nothing to do with the question of what is sufficient notice to the trustee.
Well, it's sufficient notice, it seems to me, would be, sufficient notice would be notice that would allow the trustee to for example, replace non-conforming loans.
Oh, yes, Your Honor. Now, and of course, may I continue, Your Honor? I acknowledge that the light's on. It is important to remember the allegations here. We allege, for example, that the trustee, as it was required, the trustee or the custodian on his behalf prepared the certifications and required exception reports. So the trustee, we allege, and they don't dispute, created spreadsheets with hundreds, sometimes thousands of entries listing defects on the loans. The trustee was required to provide those detailed loan-by-loan, defect-by-defect spreadsheets to the obligor. We allege that that happened. And the only question here on notice is, was the trustee subsequently made aware of the obligor's failure to cure those loans, which means in this context, the trustee knows exactly which mortgage files are defective because the trustee gave that information to the obligor. That we allege and
So
they
notice,
do not
so
dispute.
it's notice to itself, essentially, you're arguing. It had notice, it's its own notice, right? It got notice based on its due diligence, for example.
Now, the notice here, in fairness to U.S. Bank, is that the obligor failed to cure the loans that the trustee gave its notice of. It is a strange argument, if you will, if I give you a list of 1,000 things to be fixed and all I receive back from you is silence. I think I'm on notice, but they say written notice, and so we allege extensively in the complaint that they were aware that the defects were not cured after providing the obligor with this detailed loan-by-loan list.
Thank you. Thank you very much.
Thank you, Your Honor.
Just picking up briefly to Justice Moulton's question on the written notice, they have not alleged that written notice back to the trustee. And I think it's clear from the Court of Appeals cases that in this context, the written notice has to at a minimum be trust-specific to say that the party hasn't cured. And that.
What about their argument that through the due diligence of the trustee, they're on notice of the non-conforming loans, and that's sufficient notice?
Well, you're on notice of the notice you gave, what the trustee gave. The trustee doesn't know if those defects are material. It doesn't know if those defects are subject to loan to repurchase. All it would know is what's in the exception report, which identifies exceptions, which are not the basis for the repurchase of a loan. There has to be a material, a material defect that harms the interests of the certificate holders generally before you can have a repurchase. And the language varies slightly, but there is a qualifier to those defects before an exception becomes a material defect. And turning back to the U.S. Bank v. DLJ, I think that the kinds of arguments that the plaintiff makes here and the motion court accepted are exactly the kind of arguments the Court of Appeals has continually rejected in these cases. And I think those arguments look at the financial crisis, they look at the challenges that came up, the losses that came up, and they sort of assume there must be in this contract somewhere some remedy for all of it. And in the context of the repurchase protocol, the Court of Appeals has said no, right? In DLJ, the other side, the dissent said, well, this is going to leave a lot of damages unrepaid. And the decision from the Court of Appeals was we're going to follow the contract as written. The repurchase protocol is loan-specific. It talks about mortgage loans. It wasn't implying anything in that contract. The repurchase protocol says mortgage loan, and the Court of Appeals held that means notice of a specific mortgage loan. And the kind of argument here that the trustee must have an enforcement obligation, there must be one there somewhere, that runs afoul of that direction from the Court of Appeals. These contracts are interpreted as of the time that they were signed, and not on the basis of hindsight, and not on the basis of the assumption that any ills that have arisen over the course of the transactions can be cured, because that's exactly why the trustee negotiates in Article 8. So it does not transform into a guarantor of the obligations of other parties and into a guarantor of the bonds. Because you could always take the title trustee and look back historically and saying this entity with the title trustee could have done any number of things. When this case was filed in 2021, there's a lot of things you can look back for from 2021 to 2007 and say if only somebody had done something different along the way, these losses would have been avoided. And the reason why the trustee negotiates for and accepts an appointment as trustee with the limitations in Article 8 is so that it is not transformed via this kind of after-the-fact litigation into the guarantor of other parties' obligations. Thank you.
Thank you. Thank you both. Next matter is Young versus 1530 Rosedale Partners.
Good afternoon, Your Honors. May it please the Court. Rebecca Miller on behalf of the appellant. It is the appellant's position that the court overturned the lower court's decision granting plaintiff summary judgment on liability. There are several questions of fact that we believe a jury should decide.
One question of fact that didn't seem like a question of fact to me was Buddy Young's behavior. The young man who's alleged to have put his foot on the balustrade to adjust a light bulb.
Right.
I mean, isn't that just a matter of comparative fault? He's a second-party defendant, I believe. So wouldn't he be in the mix in terms of like being a potential person who contributed to the condition that caused the fall?
Yes, he is a third-party defendant now.
Since it would only go to comparative fault, why would it stop liability in favor of the plaintiff at this stage?
His behavior caused the broken handrail. There's testimony that shows that the plaintiff and her family members were the only ones that had access to the stairwell, and the handyman that works at the building before plaintiff's accident had seen him stand on the subject handrail to change a light bulb. That was a
Yeah, I'm just getting to the, I'm just saying, isn't that a matter of comparative fault and therefore something that happens after a finding of liability? If there's a finding of liability in front of the plaintiff, what does it matter what Buddy Young did?
Because if he caused the broken handrail, then the appellant wouldn't be on notice. It could have occurred. It could have occurred.
Well, so we don't.
We have no idea when it occurred.
Right, we don't know when it occurred, so we don't look to whether there was notice, whether it was repaired, whether it was not repaired. None of that matters. We just look to the fact that there's something in the record or testimony in the record that he caused the broken handrail.
The testimony just establishes that, in fact, he did stand on the handrail on at least one occasion.
Right, but we don't know. We don't know when that occurred in relation to when the handrail was allegedly repaired, right?
I believe the testimony, it was like around the time that he purchased the building, so I think that was a few months before.
So there's
That's
a
when-
January 30, 2017 unsigned work order. Is that what you're referring to? Is that your evidence that there was a repair?
Yes, and as well as the testimony from Mr. Delgado and Mr. Batra that it was repaired before.
Well, it's an unsigned work order. I thought, I may be confusing cases, but wasn't there something about how payment was made, and yet there's no evidence of the receipt of payment?
I don't believe so. They both testified that in fact the handrail was repaired and that plaintiff.
When Mr. Delgado comes out to do work, he's paid by check. That was the testimony of Mr. Batra, right? He's paid
Right.
by check.
He's paid by check, but there's no evidence or no record of any canceled check?
Correct. We just have the invoice that the repair was done, and there was also testimony.
Is it an invoice, Counselor? Is it an invoice? It doesn't have anything indicating paid either. So,
Yeah, I don't think that
isn't
was
it
ever
an
requested.
estimate? Couldn't a jury find that it's an estimate?
Excuse me, what was that?
Couldn't a jury find that this was an estimate, that the work order was an estimate, precisely because there is no proof of payment, there's no sign-off by the tenant either?
I don't believe there was ever testimony that proof of payment doesn't exist. It could, but there's also testimony that
Well, proof of
repair was done.
proof of payment may exist, but do we have the proof here in the record?
No.
So isn't that necessary? You can think about that on your rebuttal. Thank you.
Thank you.
Good afternoon, Your Honors. Mariel Crippen, Burns and Harris for Plaintiff Respondent.
So, Counsel, why doesn't the unsigned work order, maybe proof of payment goes to the weight we give it, with Batra's testimony that he told Delgado to fix the banister, and the handyman's testimony with respect to it, why doesn't that raise an issue of fact?
Sure, that does not raise an issue of fact as the plaintiff's prima facie showing of constructive notice. Now, that is January 30th, 2017. Plaintiff Juanita Young testified that the handrail had been loose for 8 months, which puts you in March of 2017.
Her son testified that it was perhaps 2 to 4 weeks before the injury.
That's when it became fully detached from the wall. So for a period of time, it was loose, and that's what Ms. Young said. She had not seen it detached from the wall, but it was loose for a period of time. That is also what the daughter complained to the landlord about, which was also, she estimated, in March of 2017. Even assuming, if we accept this work order, which is unsigned, and I do want to address, there was testimony that if Mr. Delgado had done the repair, there would be an invoice saying what he did, and there would be proof of payment. None of that has been
There was an
produced yet.
allegation that Section 8 did an inspection, am I right?
There was an allegation of that. There's no record of that as well. There's also no inspection done by the defendants themselves. So the lower court determined that they had constructive notice as a matter of law, and that not necessarily a cause and create theory based on the repair. Delgado said there were 2 repairs.
Do we have anything in the record that shows that a Section 8 violation was placed?
I don't see anything in the record for a Section 8 violation specifically. But that being said, we have the plaintiff's testimony, we have her son's testimony, we have her daughter's testimony, we have her grandson's testimony that puts a completely detached handrail for at least 2 weeks up to 2 months. Her daughter said it was November of 2017 that it became fully detached from the wall, and it had been loose since March of 2017. That is all after this work order, if we even accept this work order as proof of anything, because Mr. Delgado said his first repair was sometime when they first purchased the building, which would again somewhat coincide maybe with this January 2017. We have 8 months at least of constructive notice of a loose handrail, which then gives you then up to 2 months to 2 weeks of constructive notice of a detached handrail. So even
How does the defendant have constructive notice if their claim is that when they got notice, the handyman made the repair? But what's the constructive notice?
they're saying that the handyman made the repair in January of 2017 based on this work order, but that complaint would be also actual notice. The complaint would be March of 2017. So that's after this alleged repair that there is no evidence of whatsoever. On top of that, you have the fact that Buddy, there's no evidence whatsoever that Buddy ever broke the handrail at all. There's no one ever testified to that. Delgado testified that the one time he saw him was around the time that the building was also first purchased, which would then be in early 2017.
Counsel, you touched on an important point that the only regular inspection that even Mr. Batra said happened was by the Section 8 authorities, correct?
That's correct. And they said that on the record, that they do not inspect the handrail. I mean, they do visit the property, and it's there to be seen. That defect is visible and apparent, and it is their responsibility, and part of their responsibility includes reasonable periodic inspections. And here, a reasonable periodic inspection would have revealed the loose handrail, which ultimately became detached well in advance of plaintiff's accident, such that it could have been properly repaired. So I think the lower court was correct in determining that there was constructive notice on the jury sheet. Any issues of comparative fault on the jury sheet, was the defendant negligent? The answer is yes, the court determined that. Was it a substantial factor? That goes into, then was Buddy negligent? Was plaintiff negligent? Was their negligence a substantial factor? But at the end of the day, plaintiff established that they were negligent as a matter of law on a theory of constructive notice, and they did not come forward with any evidence in admissible form to defeat that showing.
Thank you.
Thank you.
I just wanted to, with regards to Buddy Young, his motion for summary judgment was actually recently just denied because of questions of fact.
Counsel, how do you address your adversary's position that you're under an obligation to make, I guess, reasonable inspections, and you failed to do it, and therefore you are presumably on constructive notice of the condition of the...
Mr. Batra did testify that there was no set schedule for inspections, but he testified...
I'm sorry, I'm not hearing you clearly.
He testified that he was at the building on average once a week or once every other week since that building was acquired. So his testimony was that there was no set schedule for inspections, but he was at the building.
He also testified that he never created a record of any visit. And he could not tell, well, obviously, he said he would walk through and do any necessary repairs, and he would go once a week.
Yeah, it's a small building, and he works there, and Mr. Delgado works there. He comes to collect rent. He's there for, if a tenant has a complaint, he's there. So.
But he also said he did not know when the subject stairway had last been inspected, and he was not present when there was any type of inspection.
Yes, but according to his testimony, he would have been at the building either that week or the week before.
But there's no record of that to show that he was in fact there. In fact, the only records that we do have is the unsigned work order from January, which presumably maybe someone took care of, but there's no canceled check to even support that. So I'm just not understanding how your argument.
He does not have a written record, but he's at the building.
So the work order could be viewed as an acknowledgement that the owner had noticed that there was a defect, since it says, what does the work order say? Fix and reinforce the banister. And it gave an estimate of $450 out of the $7,500 total to repair that particular apartment, right?
Yes, the testimony is that from Mr. Batra and Mr. Delgado, that it was repaired, that invoice was generated, and that even plaintiff and her family were there for the repairs, and they looked at it and said it was okay. That was the testimony. They were in their apartment when the repairs were being done.
But they didn't sign, nobody signed off on the work order, and that was the customary practice at the culmination of repair work, right?
If I recall, the testimony was that a tenant can make a complaint. It would go to Mr. Batra or Mr. Delgado directly. They would make the repair, and then that invoice would be generated. I don't recall any testimony about it being signed off afterwards.
Thank you very much.
Thank you.
Cologne versus Teachers Retirement. Whenever you're ready.
Thank you, Your Honor. May it please the court, my name is Jameson Davies for the appellant. This court should reverse Supreme Court's decision. The New York State Legislature passed a law making it easier for a public employee who died from COVID-19 after reporting to work in person to obtain the higher accidental death benefit by creating a presumption that the infection was contracted as a result of the performance of the employee's duties. The law provides that if a member who reported to work in person after March 1st, 2020, contracted COVID-19 within the next 45 days and died as a result.
Counsel, if I could just ask a question before you continue. Does the TSR's actions in failing to direct the information to the proper address, even though they had been notified of an address correction, how does that play into the fact that the law changed? Because presumably maybe Ms. Cologne could have executed her rights prior to the law change.
Yeah, and that's partly what Supreme Court relied on, but the record bears out that it wouldn't have made any difference. The change of address was sent on April 25th. The original letter was sent to the wrong address 3 days later on April 28th. And it's undisputed that she had proper notice no later than May 19th, which is only 3 weeks later. TRS, in all of its correspondence, told her that these claims take weeks to months to process. So there's just no way that even if she had gotten the letters 3 weeks earlier, she would have finished the claims process and been paid out before the law went into it.
I'm sorry, when did, he died on April 16th?
Correct.
Right, and she sent that letter, the first letter, April 24th.
I believe it was April 25th.
Okay, April 25th. And then when did they notify her?
So they sent the initial batch of letters that were sent to the incorrect address. They hadn't processed the change of address. This was COVID time, so the change of address processing was a bit slower, but she had notice undisputedly no later than May 19th.
And the law passed May 30th, correct?
And all the letters that TRS provided her, all the letters say that these claims take anywhere from weeks to months to process. So there's just no reasonable likelihood that the claim would have been finished processing before the law went into effect. And then TRS would have been obligated by the law, retroactive to March 1st, to pay the benefit to the statutory beneficiary. Turning back to just the statute's text, the text is explicit. It says that if the person dies of COVID, quote, such member's statutory beneficiary shall receive an accidental death benefit. And these courts have been clear that that shall is mandatory language. It obligates TRS to pay that accidental death benefit to the statutory beneficiary. The only exception is if an ordinary death benefit had already been paid before the TRS became aware of the accidental beneficiary death, the statutory beneficiary, or if it had already been paid for some other reason. In that case, it gets reduced. But the legislative history and the text of the statute make it clear.
And the past tense, I'm sorry, the past tense is important, right?
Correct.
It's not payable. That's the point you make in your brief. It's paid.
Correct. And throughout the statute, it makes the distinction between claims that are payable and claims that are paid. Even within that very section, it says, that's 607-IB, it says any amount payable as a result of this section shall be reduced by any amount paid by such member's retirement system to any recipient of ordinary death benefits. So it's clear that the legislator used that distinction in tenses advisedly, and the legislative history bears that out as well. In the fiscal note, it says that this benefit should only be reduced by any amount that, quote, had already been paid. That's the Drafting Commission report fiscal note. And the legislative history makes it clear, if the text was already not clear, that it's only reduced if a benefit had already been paid. This reading also doesn't raise any constitutional issues because it doesn't reduce any benefit. There's the exact same rights to designate a beneficiary after the law was passed versus before it was passed.
So petitioner argued, I think, that their benefits and rights were diminished, I guess, by the statute.
Correct. I think at the outset it's important to note that the benefits and rights who we consider whether they're diminished are the members' benefits or rights, Mr. Barcelos. And here, none of his benefits or rights were changed. He had the exact same right to designate his beneficiary. His beneficiary wasn't changed, unlike the law in Macaulay, which in any event was held to be perfectly acceptable. It's just changed the circumstances under which an accidental versus an ordinary death benefit would be paid, which is a longstanding feature of the statute going back to the RSSL's inception. Decades.
So there's no diminution in the amount. Is that correct?
Correct. There's an enhancement in the amount.
It's an enhancement in the amount. The only change, I guess, is who would be entitled to the monies.
Correct, and it actually is, the accidental death benefit is always given to the statutory beneficiary. It's just the circumstances under which it's ruled to be accidental versus ordinary, and it made that easier. Similar to the WTC laws, which had done it for people who have conditions relating to work at the World Trade Center, similar to the HART bills for firefighters. It just changes the causation standard, but it doesn't otherwise alter.
And the statutory beneficiaries would be the children.
Yeah, it goes in order. It's the spouse first, then minor children, and then a few other.
But under
so on
these
down the line.
circumstances, it's the children, right?
Right, it's Mr. Barcelo's minor child. And just one final point, just as a matter of, I think the court was concerned about the equity here. Ms. Colon was not left with nothing. She got $627,000 from his pension fund. She just didn't get the additional ordinary death benefit.
Right, so that was the annuity, right? 627?
I believe it was an annuity, yes. Unless there are any other questions, I would urge this court to reverse and dismiss the petition.
Thank you.
May it please the court, Anne Marie Buller for respondent. I'd like to introduce Kirsten Miller. I request that she permitted to argue this appeal pro hoc pursuant to the court's order.
What state is she admitted in?
DC and Maryland.
Thank you very much. So the application is granted. You may proceed.
Thank you, Your Honor. Good afternoon. Kirsten Miller for petitioner respondent Anne Marie Colon. A Supreme Court's decision should be upheld for 3 reasons. First, as Supreme Court correctly understood, the plain language of the law did allow the benefits to be paid. The amended
I don't
law.
understand that argument. The statute says that a member statutory beneficiary shall receive an accidental death benefit unless such statutory beneficiary elects to receive ordinary benefits. Doesn't the shall sort of end the case?
Your Honor, the statutory beneficiary will always receive some form of accidental death benefits in this case. The only question is, do they get the full amount or do they get an amount that is reduced by an ordinary death benefit that is paid?
So here's my question. This obviously is an Article 78. Is it your position that the legislature doesn't have the authority to make a decision as a matter of public policy that enhanced benefits are going to be paid to the survivors, the children of people who get COVID while they are actively engaged in public service?
Well, Your Honor, as the Court of Appeals has said in several cases, we have to uphold the Constitution no matter the consequences. In Birnbaum, the Court of Appeals said—
that's not my question to you. Is it your position that the legislature doesn't have the power to assist the surviving children, in this case,
They certainly
of
could.
people who've died of COVID while they were actively engaged in public service in New York State?
Your Honor, the legislature always had the right to enhance benefits going forward. The issue in this case is that they enacted the law 6 weeks after Mr. Barcelo had already died. And so Mr. Barcelo—
They didn't know that he had died. Let's just make it clear that this is not specific to Mr. Barcelo at any point in time, right? And we are always dealing with the issue of statutory construction. Here, unlike many other statutes that are prospective in nature, you have a retroactivity component. Are you saying that the legislature doesn't have the authority to make enact a statute retroactive?
Your Honor, I'm not saying that they never have that authority in all cases, but what our argument is that under the Pension Impairment Clause, courts have struck down retroactive applications in circumstances like this.
But how was the teacher's benefits reduced? Those benefits, certainly it's just a question of allocation between survivors. So how is the Constitution even implicated?
Of course. Well, if the right to choose your own beneficiary isn't important, then the legislature could say your benefits are going to anyone. For teachers, the legislature could say your benefits are going to your teacher's assistant if that right isn't important and protected.
But that's not the situation here. The situation here deals specifically with the surviving children of the decedent who are under 25 years of age, who under, strained financial circumstances could become the responsibility, the financial responsibility of the state, of New York State, if provision isn't made for them. So why is it that this public policy decision by the legislature can't be upheld?
Your Honor, again, by expanding the circumstances in which accidental death benefits are paid, the legislature is restricting the circumstances in which a member gets to choose their own beneficiary. Mr. Barcelo.
No, it's just about allocation, isn't it? That's all we're talking. It's not as if, there's no restriction saying it can't be to the beneficiary you're choosing. What my colleague is suggesting is that is what the legislature did is took into account COVID affects families, and giving children a chance to get a portion of those benefits, right? It's not all that occurred here?
So you're arguing because he did not name the children as his beneficiary, the beneficiaries, that they're not receiving the monies. He named his companion as the beneficiary, and she should receive all the monies, and the children should not receive those monies.
Well, Your Honor, that was always a possibility. He always had the right. And what the Court of Appeals said in Birnbaum is
But
that...
is that not what you're arguing, that she should have received everything and the children should not have received
That's
these
correct,
specific
because
funds?
it was not an in-service accident as it was defined at the time that he died. He didn't have the opportunity to consider whether he would die from COVID, whether that kind of in-service accident would occur. He never could have foreseen that COVID would be considered to be an in-service accident. And in doing so, the legislature prevented him from making informed decisions. If he had known that COVID...
I'm sorry. So are you taking issue then with that it states in service?
Yes, accidental death benefits. At the time Mr. Barcelo joined the system, at the time his rights under the pension system were fixed by the Pension Impairment Clause. Accidental death benefits were only in a situation where it was a sudden, unexpected, identifiable event at work.
And so should the legislature have not made some provisions for the fact of what COVID did and what COVID caused, and then folks were dying and people died, including Mr. Barcelo died from COVID?
But Your Honor, again, the law in making it retroactive prevented Mr. Barcelo from being able to understand, from being able to make plans regarding the availability of his pension benefits. If he had known that COVID was going to be considered an in-service accident 6 weeks after he died, maybe he would have married the petitioner in order to convert her into his statutory beneficiary. Maybe he would have taken out a life insurance.
What stopped him from doing that? He'd been with her for 10 years. And he hadn't done it, so why should we assume that that's what would have happened?
But Your Honor, we can't make any assumptions. He was the one who should have had the right to make plans regarding the availability of his pension.
All of these people who, some of them, as we know, were intubated, that if maybe a decision shouldn't have been made by the legislature to help out the surviving children who were minors.
But again, the legislature is taking that right.
A lot of people never had a chance to figure all of this out. So in comes a legislature and says, we're going to protect your kids. And you're saying that that's an irrational decision that should be nullified by us.
But as the Court of Appeals said in Scaglione, we have to uphold the Constitution no matter what the consequences.
So again, you're saying that the legislature took away his right to not have any monies distributed to his children or his child, and rather have all monies distributed to his companion for the past 10 years.
The legislator took away his right to choose his own beneficiary, which, as the Court of Appeals said in Caravaggio, is an important right that cannot be impaired.
Did your client get any money?
I'm sorry?
Did your client get any money out of this?
Under a completely separate part of the pension benefits, yes.
So then, I just don't understand. Weren't his wishes then essentially accommodated? That your client got a substantial amount of money?
So she received $627,000 and change, and if she had received these death benefits, how much would she have received? An additional $400,000?
The benefits at issue are $439,000, Your Honor.
And instead, they went to his child, right?
Who was 13 years old at the time?
Your Honor, I'm sorry?
13, a 13-year-old.
Not
but
a
I'm just saying,
13-year-old, no,
Instead, they went
she's,
to the child and not to her. Is that what occurred?
that is correct, that is what happened.
So the constitutional violation is that he wasn't able to have his domestic partner get the money as opposed to someone to his child?
Right.
That's what
Constitutional violation is that he was not able to choose his beneficiary, and the Court of Appeals said in Caravaggio that that is an important right, and under the Pension Impairment Clause, it fixes the rights of members at the time they join the system, and those rights cannot be impaired no matter the consequences.
But not to belabor it, but COVID was not an issue in terms of in-service, action or causation, right? We didn't know that when he joined in terms of COVID. That's what the legislature was trying to remedy.
Well, Your Honor, it's interesting, the point about the presumption, because in every other situation where the legislature has created presumptions, in the World Trade Center cases, in the HART bills, all of those presumptions were always a rebuttable presumption. What this law does is it creates an automatic, irrebuttable presumption. So even if the health department was able to trace a member's COVID infection to a super spreader
Right, I
event
was
that
thinking
occurred
about
outside.
that. So what you were saying is that his COVID, contracting COVID was not in service, that somehow he contracted COVID somewhere else, and should there have been some type of hearing or something of that nature to determine the cause where he
Well, exactly, Your Honor,
COVID?
and the law takes away any opportunity to disprove the presumption that COVID was contracted in work.
Keeping in mind that if the determination was made that he did not contract COVID in service, then that $400,000 would not be dispersed to him.
That is the law, yes, that's correct, Your Honor. The accidental death benefits are only paid when the causation is due to an in-service accident.
Exactly, right.
Which
So
again,
it seems to me that, someone is receiving $400,000 because of this legislation, and going on your argument, no one would have received, no one in his family would have received the $400,000 if, in fact, it would determine that he did not contract COVID in service.
that's correct. And again, that was the law always. That was what he understood it to be at the time he joined the system, is that accidental death benefits are only paid to a statutory beneficiary if you have an in-service accident. With the Court of Appeals is always defined as a sudden, unexpected, identifiable event that occurs in the performance of job duties. This law completely upended any requirement to show that there was an in-service accident. And again, if the health department had specifically traced his COVID infection to a super spreader event that occurred outside of work, what this law says is we have to ignore the health department's determination that he contracted COVID outside of work, and we have to simply assume that because he reported to work 45 days earlier.
Counsel, you're asking us to assume that the origin of a COVID infection in a particular person can be figured out. That is remarkable. That is remarkable given the history of the pandemic.
Yeah, I don't see how you'd be able to determine whether he contracted it in service, whether he contracted it while teaching the little children or whatever he was doing with the Department of Education, as opposed to, as you said, a super spreader, or because he went to the supermarket or what have you. I don't know how you'd be able to trace that.
Well, Your Honor, you're correct. It may be difficult, and that's why we create the presumption. But what the presumption should have done, as it did with all of the other situations that created a presumption when it might be more difficult
So you want
to
to create a presumption that cannot be rebutted.
Well,
how would you be able to rebut that presumption, again, when you cannot determine where he would have contracted COVID?
And if we couldn't rebut the presumption, then the presumption would stand. But what this law did is it doesn't give anyone the opportunity to even try to rebut the presumption.
Which may be a good thing, but thank you very much.
Thank you very much.
Just a couple quick points, Your Honors. First, I think it's exactly right that because of the difficulties in causation, it's why this presumption was created. And I point out that in those other bills, the rebuttable presumption is able to be rebutted by the pension system, not by some other beneficiary who might have another claim. There's no case law.
But it is an interesting argument that perhaps he did not want any monies to go whatsoever to his children, to his child, and that instead he wanted the monies, all of the monies, to go to his domestic partner and did not want to take care of his child whatsoever. And this legislation precludes that.
Yeah, and I think that's an argument that's best taken up to the legislature. It's an argument against the idea of statutory beneficiaries altogether, which has been a feature of the RSSL since its inception, essentially. So if that's an argument to be made to anyone, it's an argument to be made to the legislature.
Now in this instance, didn't he also, my recollection from the record is that he wanted his domestic partner actually to help out his child, right?
That's in the petition. There's no other evidence of that other than an allegation in the petition.
What was her allegation? That he stated to her that he wanted her to assist with financially for the children.
Yes, nothing specific about what that meant, but that is an allegation in the petition. Just two more quick points. One, the first is that at this point it seems as though they've abandoned any kind of statutory interpretation argument and are relying entirely on the constitutional argument. And I would point out that they mentioned Caravaggio a couple times, but in Majauskas, the Court of Appeals said reliance on Caravaggio to support a permanent pension clause claim is misplaced because Caravaggio, quote, depended not upon the Constitution but upon an anti-assignment statute. And then lastly, I'd just like to point out that the importance of retroactivity here is heightened because this is the early days of the pandemic. The legislature was trying to pass a number of bills to try to deal with it. A lot of people died in those early days from March until the legislature was able to act at the end of May. And it was important to make it retroactive so that all those people who served on the front lines were able to get this benefit. Thank you, Your Honors.
Thank you. Thank you both. National Community versus Micro Office.
Good afternoon, James DeCristofaro for the appellant. This is a real estate commercial guarantee case. The appellant is the guarantor, and we're asking that this court reverse the lower court's determination of summary judgment.
What does the guarantee say?
What does the language of the guarantee say?
Yes, the language of the guarantee.
Well, I don't have it committed to memory, but as I recall,
A continuing guarantee and shall survive the sublease expiration date or the sooner termination of the sublease. So now we have a subsequent lease. Why would the guarantee not continue?
because the underlying sublease was terminated. And if the court would look at page 62 of the record.
I'm looking at page 66 of the record, and it says, notwithstanding anything contained herein to the contrary, the guarantee of sublease executed by Micro Office Management, LLC, shall remain unmodified and shall continue in full force and effect.
Right, here's the issue with that.
What's wrong with that?
Well, there's three issues with that. The first is that on page 62 of the record, it says that the underlying sublease was terminated. That's in no uncertain terms. The second issue
You're talking about the whereas clause.
Correct.
And how do we traditionally view whereas clauses? I mean, how does that come into contractual interpretation? Does it help, for example, is it used to determine if there's an ambiguity what the parties intended?
Well, I think it talks about the predicate for what is about to come in the agreement, and the predicate is because the underlying sublease terminated, here's what's happening. As you can see, the rent changed, the terms changed, the security deposit changed, and a bunch of other factors, material changed. But to get back to the other point, the second thing is if you look at the conduct of the parties, there was also a holdover proceeding here. And a holdover proceeding only commences when the underlying lease has terminated. So there's really sort of
But landlords lose holdover proceedings all the time, and the lease can continue after unsuccessful holdover proceeding, correct?
yes, but here there's two factors. Number one, the lease terminated by its terms. The landlord terminated the underlying agreement. And the second thing, as I mentioned, there was the holdover proceeding.
Well, in
right?
terms
And
of the
then-
holdover proceeding, there are cases that say that a commencement of the holdover proceeding does not manifest an unequivocal intention to extinguish the sublease, right? And also here we have a stipulation.
But even so, we have, this case is a little bit different than the ones that are typically decided in the context of motions for summary judgment in lieu of complaint, because here, there is the additional fact that the sublease was terminated. There is the additional fact of the arrears being settled for a different amount. There is the additional fact of additional rent as well. And so the profile of the risk naturally changes for the guarantor.
Counsel,
Here,
isn't
the
this just a
guarantor just,
modification of the agreement between the parties? I mean, you have the settlement in 2019 talks about the reduction of arrears, the reduction in the monthly base rent. It adds $75,000 into the security deposit, and it says that the termination, what is this? Termination of the subtenancy is effective February 28, 2019. The sublease remains otherwise unmodified, and the guarantee continues in full force and effect. So you have a complete agreement. Why isn't this a modification? It doesn't sound like a novation to me.
well, yeah, because so the very simple fact that the lease was terminated, I mean, I've been thinking about this quite a bit to sort of understand, okay, let's say that the sublease was terminated, and then the same exact sublease was reactivated. Does that mean that the guarantee is extinguished? I don't know what the answer is to that. I've been trying to think about it. However, that's not what happened here. The agreement terminated, the risk for the guarantor changed, and therefore there's a new sublease with these.
Except for the fact, as my colleague indicated, it says that the guarantee remains unmodified and shall continue full force and effect.
Right, but if you look
So
at
that
the
was
party.
taken into account.
Right, but if you look at the parties to that agreement, to that stipulation, it doesn't involve the guarantor. So here, the guarantor is being, the guarantor's rights are being modified without the consent of the guarantor.
Thank you.
Thank you.
Good afternoon, David Wolf for the plaintiff respondent, NCRC.
Counsel, can you?
Go ahead.
Well, I just wanted you to pick up where he left off in terms of the guarantor's rights being modified without the consent of the guarantor, saying that he wasn't a party to this stipulation. So how should we view that?
Well, it's an absolute and unconditional guarantee with a full waiver of all defenses, and by its very terms, it applies to all amendments and modifications without notice to the guarantor. We also have, this is the subtenant was a wholly owned subsidiary of the guarantor. That's specified in the guarantee itself. And in addition, the modifications such as they are greatly lessened the risk to the guarantor. So appellant's counsel uses the term that the risk was modified, and that's a very coy way of saying, yeah, there was a change for the better for them. The arrears that had accumulated up to that point were cut. The rent they'd have to pay going forward was cut. The security that would protect the landlord in the event of a default by the subtenant was increased, which has the effect of lowering the risk for the appellant.
To their benefit, unless you found that the guarantee was extinguished, right? Because if the guarantee was extinguished, then, you know, they would have no further, they would have to pay whatever up to that point, but there would be nothing further going forward.
So the guarantee by its terms also says that it will outlive the sublease. So even if the sublease were actually terminated, which it wasn't, a notice of termination was sent and a holdover was started, but that was settled. It was compromised. Landlords, as Justice Malton pointed out, landlords lose holdovers all the time. So we don't have a bona fide, a genuine termination here. We have an agreement which by its terms, it says, this is a modification.
Right, but does it
Remain,
matter,
continue.
I was wondering, does it matter whether it's a modification or an novation given the terms of the guarantee?
It doesn't, and the
I mean, it would appear to be a modification.
right, so appellant's argument, perhaps if at the end of the term, I think it was a 10 or 15-year lease, I don't recall right now, but if at the end of that, 10 days later, and there's a clear lapse, right? The lease naturally ended, not that it was prematurely ended with a notice of termination. But let's say 10 days later, they enter into a new extension, and they call it an extension, but there's been a lapse. That's maybe a renewal. Maybe there would be some merit to it there, but that's not what happened here. Their argument is essentially that because the landlord served a notice of termination and started a holdover, as opposed to starting a non-payment, the guarantor gets this windfall of being let off of the hook for their wholly owned subsidiary's undisputed default. They don't even submit an affidavit of anyone saying, we weren't a party to this, we weren't aware of it, we didn't consent to it. They don't say that they're prejudiced in any way by it. They're just trying to seize on and take advantage of the service of a notice of termination, where the parties themselves, the sublandlord and the subtenant, worked out a stipulation which essentially walked back and ended the notice of termination.
And also, I mean, your opponent concedes in his brief that the existence of a novation, say a novation does help them, let's just assume that. But they do concede that the existence of a novation depends upon the intent of the parties. And you'd agree with that, of course, as well.
Sure, if the parties intended.
And so in the stipulation, which is supposedly the thing that ends the tenancy or the initial contract, it says in many places, some of which have been read by my colleagues, that it's a modification. It never says that we're ending this contract and starting another, correct?
That's correct, and there's been no affidavit from anyone saying this wasn't what the parties said it was. It's very clear from the agreement itself, this is a modification, the lease remains in effect, and there's no reason to interpret it in any other way.
Thank you very much.
Thank you.
The way that this came to light was the CPLR 3213, which is for the payment of the instrument of money only. And because there are other factors here that we've been discussing, for instance, the risk to the guarantor, which, you know, one can interpret it as, okay, because there was a lower payment of arrears, that could have potentially lessened the risk to the guarantor. You know, there's been no discovery yet in this case on, for instance, the position of the subtenant after it makes that big cash payment. So it does indeed change the risk profile of the whole deal. And to the point about the wholly owned subsidiary, we see parent and subsidiary guarantor tenant relationships all the time. There's no allegation here about separateness or lack of separateness of the entities, and just because they may be related doesn't mean that one knows what the other one is doing, particularly in this context. So I'd ask that the court reverse the lower court's ruling. Thank you.
Thank you. Rosenthal versus Roosevelt Island.
Good afternoon, Your Honors. Stephen Storch for the appellant petitioner Susan Rosenthal. Your Honor, the decisions below presents an irreconcilable conflict. It contradicts itself, and it has created a situation where the petitioner will not have an opportunity at any level to try to clear her name and also to seek damages.
For a name-clearing hearing, does the petitioner have to come up with some quantum of evidence to show, for example, discrimination or something sufficient for the court to order a hearing?
The answer, I believe, Your Honor, is no. With respect to the name clearing, what she has to show is that she has been, and she was here, branded a racist.
She didn't make some of the remarks?
And she's denied that. That's correct, Your Honor. And in fact, they said these remarks were set forth in an audio tape. We asked below, when was the tape taken? Where is it? Who took it? Can we hear a copy? Can we hear it? They said no. The court below ordered them to produce it, finding that there were disputed issues as to what was on the tape, and that we were entitled, there raised issues of fact, and we were entitled to see it. They disregarded the order. They refused still to produce the tape. Then
Counsel, I have a question, and just going back to the name clearing hearing, was that requested down at the court below, that specific hearing? Is that issue preserved for our review? And then my second question to you would be, this particular employee was an at-will employee?
Correct.
Okay.
All right, so, well, you can answer those questions because I was trying to figure out the basis for the Article 78 was whether or not, obviously, her termination, the ruling was arbitrary and capricious, right? So I'm trying to figure out what was the basis for the termination given. But you can, if you can answer those questions first.
Okay. In terms of the preservation, Your Honor, we believe it was preserved. The Article 78 petition is permeated with how branding her a racist ruined her reputation, impaired her ability to find the employment such as she'd been enjoying through her legal career.
And in her petition, she asked for this, specifically for this name?
She asked for reinstatement and for such other relief as was due and warranted.
And so that catch-all for such other relief, you're arguing would be for a name-clearing hearing.
Exactly, and moreover, under the decisions of this court, the Court of Appeals, we're not arguing any new facts here. This is all in the record. We're not asking the court to take cognizance of any new facts. We have a legal theory that we are asserting here, and even if the court found, well, you didn't assert it down or didn't make that request below, it's certainly a full record for this court to decide it and to rectify the result down there.
So your client was an at-will employee, so again, I'm not understanding why would they not be justified or within their rights to discharge her based upon the allegations that were made?
Well, because even though an at-will employee, as the cases hold, if you're terminated for an unlawful or improper reason, such as a discriminatory reason.
But how, and that goes back to my first question. How have you shown any facts alleging discrimination, for example?
Okay. First of all, and there are two prongs to this, Your Honor. One is what we have alleged, and the second is what they've come back in defense. So
what did you allege?
We allege that, first of all, that she was a white woman, was replaced by an African American, that she had was not given a hearing, was not allowed to see the evidence against her. It was on an expedited basis in violation of their rules, and then they made a decision on an expedited basis with no explanation as to why on a Wednesday, and sat on that decision until Friday, Juneteenth, when they gave a statement to the New York Post that she was terminated because she had made racist statements. And we contend that shows that she was discriminated against because she was a white woman, and with all due respect, no person of color would have been subject to that treatment.
So
now they
counsel,
came back.
I'm curious. The petitioner admitted that as to her quote-unquote occasional use of salty and ribald language. And I'm curious as to which of the horrendous statements that are in the record she admits to.
She didn't. What she admitted to was the original complaint that she had made some salty language. The defendants made a finding when they did the investigation that that wasn't sufficient to terminate her. So she said to that original complaint, yeah, I may have said something that's salty, and the defendants made a determination, it's in their papers, that that wasn't sufficient. They then went off and continued an additional investigation.
And was that inappropriate? Was that was that arbitrary to continue the investigation, given the language that was alleged?
Not inappropriate to continue the investigation. What isn't inappropriate is to call her in and say, we have that language on a tape. She says, I didn't say that. Can I hear it? They say no.
How would that have changed the outcome?
Because we don't think it's on the tape what they say is on the tape. We're not even sure if this tape ever existed.
But how would that change the outcome in terms of the determination that was made?
Well, presumably, they wouldn't then charge her with a racist and making these sexist comments if, in fact...
Also, wasn't it hostile environment? Isn't that really what they were claiming, is that the statements created a hostile environment for other folks in the office?
Well, they claim that, except nobody made a complaint. You know, these statements, which they now say created the hostile work environment, there is no evidence that there was ever a single complaint about it. They went out looking for the complaints.
I thought there was a complaint about the petitioner in the email that was circulated, that she made certain a series of offensive racial comments and jokes of a sexual nature.
Yes, there was. And they found that those complaints were not valid and that were not sufficient to terminate her. They then went off and made the additional investigation.
But this goes back to hostile work environment, doesn't it?
No, they said that wasn't sufficient to terminate her. It may sound like a hostile
They don't need anything to terminate. She's an at-will employee.
But they chose to brand her a racist. If they wanted to terminate her and just said, you're terminated.
I'm sorry, so did they say we are terminating you because you are a racist? Is that what they stated?
To the New York Post, yes. They didn't tell her. They told it to the New York Post. And
They told the New York Post that she was a racist. I thought that what they stated was that there were racist comments that were made.
That's right, which, frankly, is being branded a racist. You're saying, we had to fire the president because we don't tolerate this, and she made racist comments. In my book, and I think in anybody listening to that out in the world, in any law firm that's looking at this very accomplished...
But you're bringing in Article 78. You're not claiming any type of defamation against them.
Yes, we are. And that's...
Not in the 78.
We brought, as the judge said in his decision, he actually says that there's no evidence of races that you were terminated for racial reasons. And then goes on to say, but we really don't know what motivated it. They could be lying. So you should bring this...
Counsel, hold on, I'm sorry. You mentioned that the recordings were not produced, but there was other evidence that they had. They had complaints filed by people. They had interviewed 6 other people who gave specific detail of statements that were made that made them uncomfortable, and that was the hostile work environment. It just wasn't the recordings.
No, with respect to these statements, they lumped a number of people together. They didn't say who she supposedly said it to.
Oh, that's not exactly correct, counsel. I really hesitate to come out with what she said, allegedly, here in a courtroom, because it is that vile and that disgusting. But one of the people certainly was identified, the human resources director, a woman of color, who the petitioner allegedly said that her problem in dealing with men in business was that she hadn't learned how to. I don't even want to say it.
How to deal with men in business. But counsel,
that's a nice way of putting it.
I'm confused now. The Article 78 was based upon her termination, based upon statements that she made, based upon a hostile work environment, and also based upon, based upon that. Is that correct? Is that why you brought the Article 78 stating that the determination was arbitrary and capricious?
We brought it based on that she had been falsely branded a racist and that it was done to her because she was white, and they broadcast it out on Juneteenth to get the maximum negative...
But the determination of the Article 78 was that she was being terminated because of statements that she had made and also based upon this hostile work environment. Is that correct?
We don't know why she was terminated. They never told her. They never gave her a reason.
They never told her why.
They told her she was terminated, and they went to the New York Post and said
You keep saying that. I'm just trying to focus for 1 second. You keep talking about the New York Post, which we'll get to in a second. You're claiming now that they never told her why she was terminated.
Just said she's terminated.
But she was an at-will employee. So really, I guess you didn't have to, but we'll see whether they did in fact notify her of that. Also, in terms of the post, what they apparently stated to the post was that she was fired for making racially and sexually offensive remarks, and that she was ousted following a probe.
To me, that's branding her a racist. To people out in the world.
And a sexist, right? She's branded a racist and a sexist. Is that correct?
Well, both are wrong in our position.
And you're claiming also that there was there was a complaint filed also for defamation based upon the remarks made to the New York Post?
We filed an action for defamation, yes. There's a separate plenary action. And what happened here was the judge in this case, and I need to focus on the contradiction. He said, I can't determine what the motivation was for this firing. And I can't determine, maybe people are lying. He said, go bring a plenary action, which was then pending. And that's where you should litigate this.
Right, and I'm looking at that. I don't see, I think you're talking about Judge Engoron. I don't see him saying that, but.
It's in his opinion.
I'm looking at his opinion, and I don't see where he says, I can't tell whether this is correct or not. Go do more
One moment, I can
discovery.
point out where it is.
We'll address it on rebuttal.
Okay, thank you.
Roosevelt Island?
No,
No, I'm sorry, who wanted to go next? Please, go ahead.
Counsel, your adversary says that.
1 second. Let me just give him 5 minutes.
Sorry.
Yeah, let him introduce himself. There we go.
May it please the court, Stephen Yanni for the state respondents.
Your adversary says that his client was entitled to a hearing to clear her name, even though she was an employee at will. What do you have to say about that?
I have a couple of responses to that, Your Honor. First, this claim is not preserved. It was never raised in the petition, the request for a name-clearing hearing or a due process claim, and that's the basis for a name-clearing hearing. And
right, so he didn't have to state, he should have stated something other than and for such other relief as the court may deem proper.
That's right, Your Honor. And I mean, a different standard applies. For example, you have to show defamation and a significant impact on your ability to gain future employment for a name-clearing hearing. And otherwise, I guess the argument would be that every single Article 78 hearing would have to, a court would have to do an individual, independent assessment of whether a name-clearing hearing might be warranted, even if there's no triable issue on the actual claim raised in the Article 78 petition. So we just don't think that's tenable.
Well, that's what I was trying to determine in the actual, was there an actual termination, a notice of termination given to her, or she was made aware of, or if there was not, then was it necessary or not necessary because she was an at-will employee?
So the record shows that she was informed by telephone on June 17th that, I'm sorry, on June 19th that she would be terminated. And there's no further details as to what precisely was said. I don't believe there's details in the record that she was informed for the precise basis of the termination, but there was no need to. The state didn't have to provide her a reason. As Your Honor stated, she was an at-will employee.
The petitioner says that there were recordings that were made. I have at least two statements that were allegedly recorded, but that these weren't turned over. Was this issue raised to the court below?
The issue was raised to the court below, but the Supreme Court vacated its order that required the production of these recordings because it found it wouldn't have been material to its decision. And I think the reason for that is because it doesn't matter whether any given witness was actually lying. The question is whether the state reasonably relied on the investigation. So whether an individual witness may have been lying would have been immaterial. But in any event, Supreme Court also noted that there was no reason to believe that respondents possessed these recordings, and we represented below to the court that they were not in our possession, custody, or control.
So now in terms of the state, the allegations as to the state was that this was a rushed investigation, in quotes. Also that you made the decision, you reported this on June 19th, which was Juneteenth, although you had the information that Wednesday, you sat on it, and then you made these statements to the Post.
So, Your Honor, the key question here is whether there's evidence that Ms. Rosenthal was terminated because she's white. And none of those facts show that at all. She relies primarily on the fact that she was fired on Juneteenth, but no evidence supports the speculation that that was based on racial animus.
Well, she does say that she was replaced by a black male.
Well, that doesn't give rise to an inference of discrimination here because there's no evidence or even allegation that the executive chamber officials who determined that termination was warranted had any involvement in choosing her successor. In fact, on pages 24 to 26 of the record, the petition alleges that the state officials informed her of the termination following an investigation and that the board subsequently elected Mr. Haynes. So even on the face of the petition, that doesn't support an inference of discrimination. As for the timeline, the termination was directly followed an investigation that began on Wednesday, June 12th and lasted until Wednesday, June 17th, and that's when the decision to fire her was made. And there's no evidence that waiting 2 days, reflects racial animus, and in any event, it's undisputed that the decision was made on June 17th. So even if there was some sort of delay, that would have no bearing on the reason for which she was fired. I do want to respond to my adversary's point regarding the trial court's decision. At page 4 of the record, Supreme Court expressly recognized that Ms. Rosenthal could not be terminated for a discriminatory reason. So when it concluded that her termination was not arbitrary and capricious, it necessarily rejected that claim. And moreover, the court was on notice of how my adversary was reading the decision below. These were the exact same arguments that were raised in the motion for renewal and re-argument, but the court denied renewal and re-argument. So I don't think it's fair to read the trial court's decision to say that there was some kind of remaining dispute of fact on the issue of discrimination here.
So if the allegations are true, this was an equal opportunity offender. I'm looking at the allegations, and I don't know that I would find them any less offensive if they were said by someone who wasn't a white woman. They are per se gross.
I think that's fair, Your Honor. The trial court below recognized that any of these statements could have supported her termination, and she indeed admits to having a, quote, conceded weakness, unquote, of using salty and ribald language.
Right, but she denied making these statements.
Yes, she denied making some of the particular statements that were found to violate state policy. But I would note that, for example, for the purpose of the name-clearing hearing, where she has to show that there was some kind of stigma here, the stigma associated with saying that she had used racially and sexually offensive language is not incrementally more stigmatizing than what she freely admits in her petition that she used.
Well, your adversary states that she's now branded a racist.
Well, Your Honor, what was actually said in the statement was that the investigation substantiated that the president had used racially and sexually offensive language in clear violation of state policy and the strict standards set by the administration. And that's what she takes issue with, but it just accurately summarizes the results of the investigation.
Thank you.
Good afternoon. If it may please the court, Stephen Banks, attorney of record on behalf of the respondent Appellate, Roosevelt Island Operating Corporation.
I'm sorry, so are you two arguing? She answered the calendar call.
Yes. She's
introducing me for
pro hockey.
Oh, okay.
Yeah.
So, because you used up a good portion of the 3 minutes.
I'd like to introduce Holly Rogers, a request that should be granted the ability to participate in oral argument today, pro hoc vice, on behalf of REAC per the court order.
And where is she admitted?
Connecticut and the federal courts, all the federal courts in New York.
Okay. So now you have 1 minute. You have 3.
May it please the court, Holly Rogers for respondent Appellate, Roosevelt Island Operating Corporation. Your Honors, at the threshold matter, the Article 78 proceeding was properly dismissed by the lower court as to REAC because it is undisputed that REAC did not make the decision to terminate the petitioner's employment. It had no part in the termination decision. The case law is clear that an Article 78 proceeding cannot be maintained against an entity that had no involvement in the decision that underlies the Article 78 proceeding. So since REAC did not participate in the decision, it cannot be deemed to have acted arbitrary or capriciously. And we assert that the lower court's dismissal of the Article 78 as to REAC should be affirmed.
You're saying that the investigation and the decision was made by the Governor's Office of Employee Relations?
That's correct, yes. REAC was not involved in the investigation. REAC employees were interviewed, but REAC itself was not involved in the investigation or the findings or the termination decision.
Who hired the successor?
REAC's board appointed the successor.
Would that be a basis, based on the fact that their claim is that she was fired for discriminatory reasons and a black person was appointed?
No, Your Honor. The fact that the sole fact that Ms. Rosenthal's replacement was an African-American man with nothing else does not alone support an inference of racial discrimination. Her successor was the CEO, who had worked closely with the president and was my understanding, because I should clarify that the board members are represented by counsel for the state. But my understanding is that it was his qualification and his experience with REAC that led to his appointment, and it had nothing to do with his race.
Was he appointed prior to her termination?
No, Your Honor. He was appointed on an interim basis at an emergency meeting of the board on the day of her termination, June 19th, once the board was notified of the termination. But, you know, REAC and its board was notified of the termination after the decision was made, and it was affected by the state, the governor's office.
Thank you.
Thank you.
Your Honor, if I may read from the decision below.
Just tell me what page you're reading from.
Yes, it's page, it's record page 5, Your Honor.
Thank you.
Of course, the people to whom petitioner allegedly said these insensitive, actionable remarks could be lying, but the appropriate forum to determine that would be in a trial in a plenary action. Both sides here are entitled to discover documents and depose witnesses and to a full trial on the merits before an impartial finder of fact to determine what actually motivated respondents to terminate petitioner. Indeed, petitioner apparently has already commenced such an action, claiming that respondents violated her federal civil rights. The instant dispute belongs there, not here. So what did they do, the respondents, with that decision? They marched across to the plenary action and moved to dismiss on the basis of collateral estoppel. And the judge there said, well, wait a minute, I have to dismiss it because he must have found there was no discrimination.
Which appeal are we hearing, counsel?
I'm sorry?
Which appeal are we hearing? The one pertaining to the Article 78 or the one pertaining to the plenary action?
The Article 78, I'm just pointing out the impact of this Article 78 ruling, which has cut her off.
Before us, that's not a consideration, is it?
Yes, it is. The collateral estoppel effect of this ruling is absolutely a consideration for this court. Because now you have a judge who said, I don't know, they could be lying. I don't know what motivated them. He didn't make a finding.
When the plenary action was dismissed, was that appealed?
That's on appeal here before this court.
So we'll deal with that when we get to it?
Well, right now, that appeal will be muted if, as we believe, this decision should be reversed. A couple of...
And also, you had moved to consolidate that action with the 78, and the judge denied that.
Denied that.
So that's why it went forward as a separate action.
That's correct.
Okay.
Okay. Just a couple of points. On the tapes, and I think the tapes are very, very serious. I think their inability to say where they were, to produce them, to obey the judge's order. One thing that counsel said is not completely accurate. The judge below ordered the tapes to be turned over. In the interim, he issued his decision, which is what is on appeal. When we brought to his attention that you had already found, Judge, there were factual disputes, and you ordered these tapes produced, and they haven't produced them yet, he said, well, it's moot now, I dismissed it, go back to the plenary action. So we're now in a situation where the petitioner got no hearing before she was terminated. She's had no hearing after she's terminated. She's been cut off from asserting her rights by a decision which is now being used by the respondents here as collateral estoppel when the judge expressly said he wasn't deciding the issue. And I submit that that this case should be reversed. It should be sent back down to the Article 78 for, at minimum, giving her the opportunity to clear her name. And Judge, if I may just make one last statement, I understand how offended you are at that language. It's extremely offensive. I'm not defending it. But Ms. Rosenthal, the petitioner denies that she said it, and that's the problem. She's never gotten an opportunity to put forth her case to confront this at a hearing. And so, even in your own mind, I understand it's repulsive, but she's branded as somebody who would issue some vulgar statement based on hearsay testimony.
So, counsel, I just want to be clear, procedurally, you're asking us to reverse and to find that the determination, that her termination, that determination, is Article 78, was arbitrary and capricious based on what?
No, we're asking you to reverse and to remand it back to the Article 78 proceeding so that we can have the discovery that the judge previously ordered in response to our motion, and then we can have a hearing as to, as this judge said, what was their motivation? Were people lying? So that
So on the
petitioner
article,
can clear
so you're
her good
arguing
name.
that on the Article 78 proceeding, you have a right to a hearing and you have a right to discovery for purposes of Article 78 proceeding?
Not absolute, Your Honor, but in this case, when we made our motion for discovery, because we said there are factual disputes here, there are factual disputes as to whether this was ever said, as to whether the respondents are lying about the tapes and the other documents. The judge found there was a disputed issue of fact and ordered discovery. He ordered it. In a special proceeding, if you make a showing that there's a factual dispute, the judge can order discovery, and he did it. And then, before the discovery was produced, he issued this ruling and said, you know what? Go over to the plenary action and get your discovery there. And the result now is that the petitioner has no ability to clear her name. Anybody who reads that New York Post article, and by the way, they've acknowledged, they never gave her a reason. They didn't give her a reason, but they told the New York Post. And they waited 2 days for Juneteenth to do it. With all due respect, Your Honor, this is a horrible miscarriage. She is at least entitled to her day in court so that people don't walk around thinking she makes sexist comments or that she makes racial slurs. It is contrary, as we put in her petition, to the way she's lived her life, to the things that she has fought for, to her family. It's offensive, and she should have her opportunity to clear her name, and she should have the opportunity to seek damages.
Thank you.
Thank you.
Thank you both. Perazzo versus Lake Street Fee.
Good afternoon, Your Honors. May it please the Court, Andrew Klauber from Malaparo, Briscoe & Klauber on behalf of the appellant. It's our position that the lower court erred. Just if you look at the lower court's decision at page 8, they cite Blake and its progeny and state, once the plaintiff makes a prima facie showing, the burden then shifts to the defendant who may defeat plaintiff's motion for summary judgment only if there's a plausible view of the evidence, plausible. The court then goes down and says, grants the plaintiff's motion saying there's no conclusive evidence. Two different standards, okay? Clearly in this case, Mr. Valenti, who is a non-party, who was subpoenaed to testify, gives an explanation, a viable explanation for why this accident happened and why the plaintiff's actions were the proximate cause of this accident. First and foremost, he says that he left a brand new scaffold for Mr. Perazzo to assemble. By Mr. Perazzo's own testimony and own admission, he is a competent person to erect a scaffold. He had erected many, many scaffolds in the course of his...
There was a divergence in the testimony about whether it was the scaffold that he'd been previously using or it was the new scaffold. Right, why does that matter, though? If he fell from the scaffold because it was defective, or for no apparent reason anyway?
Well, because they're questions of fact. There are three different versions as to which scaffold was used. First, Mr. Carroll...
They have to be material issues of fact. Why is that material?
Well, it's material as to whether he constructed and put together the scaffold, first and foremost. His own testimony is Mr. Carroll brought it down from above and rolled it to him within 3 feet and that he didn't know who constructed the scaffold. He did examine it, he did look at it, and then he stood on it and then had it rolled 3.5 feet to the wall, okay? Mr. Valenti says, Mr. Carroll says, they brought it down, contrary to what plaintiff said, they brought it down together in the elevator, okay? Whether it was assembled or disassembled, Mr. Valenti said it
let's
had...
assume, yeah, giving the non-moving party the inference, all favorable inferences,
right.
The scaffold was erected by the plaintiff. The claim is essentially that it was improperly erected, correct? That certain pieces of wood were not in where they needed to be. Does that go to comparative negligence, or does that go to sole proximate cause?
Well, if you go to comparative negligence, you never have proximate cause. You eliminate proximate cause by saying it's comparative, okay? There's no question in this record that this is the proper equipment for the job. He didn't ask for any other equipment. There was no other equipment requested. Based on the fact that Mr. Valenti said, use the scaffold down here, it was assembled, he came back, it was in partial disarray based on what happened, and that Mr. Valenti put it together thereafter, had absolutely no problem, creates an issue of fact as to whether it was his sole proximate cause in misassembling it.
So in other words, by not aligning the planks with the pins goes to sole proximate cause as opposed to just straight comparative negligence.
Because by Mr. Perazzo's own testimony, he was a competent person. He said when he checked it, okay, if the pins weren't in place, he couldn't use it. So the pins had to be in place. There's no defect. There's no expert testimony there's a defect. There's no...
Is that a requirement on a summary judgment motion? Isn't sufficient?
Not a requirement,
but isn't it sufficient to show that, in fact, that there was inadequate protection provided to the worker? Isn't that all that needs to be shown?
Well, yes and no. The bottom line here is that there's a question of fact that the court ignored by saying conclusive as opposed to plausible view of the evidence. If you look at a plausible view of the evidence, Mr. Valenti says there was a brand new scaffold that was there for Mr. Perazzo, that he assembled it, that when, after the accident, that he reassembled the scaffold and didn't have any problems reassembling it and using it.
Didn't Mr. Valenti say that he didn't know what was the cause of the accident?
Excuse me?
Didn't Mr. Valenti say that he didn't know what was the cause of the accident?
He wasn't 100% sure, but he said, and Mr. Chiaffo's C3 also indicates that the failure to place the pins was the cause of the accident. So in combination...
I'm sorry, is that statement, I apologize, is that statement made on personal knowledge, in fact? I know on the C2 form, there's a reference to it.
Right.
Any personal knowledge about in fact, that it wasn't properly seated?
Well, Mr. Valenti said that Mr. Chiaffi conducted his own investigation, and that was his conclusion.
Personal knowledge?
Yes.
But he didn't recall what his conclusion and that of Mr. Chiappio was.
That's correct, but he said that Mr. Chiaffi also examined it.
In reference to the scaffolds.
The bottom line is that there's a plausible view of the evidence here that it should go to the jury. There are enough different stories here and different possibilities here that's a plausible view that should defeat a motion for summary judgment when it's looked at the light and most favorable to the non-movement.
Thank you. Thank you.
Sorry,
well,
go ahead.
Good afternoon, Your Honors. May it please the Court. My name is David Perisman, and I represent the respondent.
So, Mr. Perisman, why wouldn't, if your client didn't lock the pins properly and place them on the scaffold, why wouldn't that go to sole proximate cause as opposed to comparative negligence?
It wouldn't. It's no different than the decision in Ordonez, Bermeo, Ernish. Ordonez, failure to lock wheels, not sole proximate cause. Bermeo, failure to lock clips. Same as this. That's what those pins are. Clips, not sole proximate cause. Ernish, faulty rigging by plaintiff of the scaffold, not sole proximate cause. And something needs to be made a point of. This whole statement about my client's alleged failure to lock the pins is made out of whole cloth. It's written in an unauthenticated, unsigned C2 by a person who could not possibly have had knowledge whether the pins were locked properly, because he received the scaffold after it was taken apart, put together, taken apart, and put together. This is Mr. Valente's testimony, and he's back in the warehouse. So how does he know whether the pin was not locked properly? And he said it the way he meant it. It appeared that the pin was not locked properly. But Mr. Valente, who was on the scene and came there to see the scaffold on the ground, said, as you sit here, do you know what caused the accident? No. As you sit here, do you know if Paul, that's the plaintiff, had anything to do with the cause of this accident? Again, I would be speculating or guessing. So I don't know what it was in his head or what happened that day, so I can't tell you. Turning to page 2 of the report, question D, it says item 11, how did the injury illness occur? Then it's typed, if Paul set up the scaffold, after Paul set up the scaffold to work on, the board came out, it appeared the pin was not locked into place, causing the platform to come down. Did you provide that information? I read to him from the C2. Answer, no. As you sit here now, do you know if that is in fact what caused the accident? I don't know. As you sit here now, have you ever heard anyone tell you that's what they believe caused my client's accident? Answer, no. As you sit here now, do you recall ever being present during which time conversation was had that indicated that the accident occurred in the manner in which it set forth in item 11 that a pin was not locked into place? Objection as to form. Answer, no. Nobody has any knowledge that that pin was not into place. Whole cloth. Second point that's very important. Under Sciami's regulations, Mr. Valente was the competent person. He was required to supervise the assembly of every single scaffold and afterwards to inspect it, and prior to its use, to tag it, that it's safe for use. He admitted he didn't do it in this case. He admitted he didn't do it with other employees, and the general contractor admitted that they had nothing in place to ensure that that safety protocol was being followed. His failure to do that, if the scaffold was improperly constructed or erected, must be seen at least as a proximate cause of the accident. And that goes along with the presumption that the plaintiff is entitled to, that this is a prima facie violation of Labor Law 240 because a scaffold collapsed. Those two things alone require the court to bring into play the Blake decision. If the defendant is violated the statute and it's a proximate cause, plaintiff cannot be the sole proximate cause. It cannot occupy the same ground. And by the way, you should know, if you look through the real testimony, there is absolutely no proof from anyone that my client erected that scaffold. It was me, according to Mr. Valente, it was a new scaffold. No pictures, and the only pictures that are there, my client took, and look in the record, I forgot what page it's on, it's at the beginning of the record, you can see that that scaffold is anything but new. So,
Thank you. Thank you very much, counsel.
thank you.
First of all, as far as the competent person, there's a question of fact as to that as well. Mr. Valente on page 691 said he didn't believe that section applied to Baker scaffolds. Mr. Perozzo also, and it was more than one competent person on the job, nobody was able to identify who the other one was. And Mr. Perozzo admitted that he was a competent person, that he was fully licensed to put together the scaffold. Okay. And there is proof at page 632. Mr. Valente testifies that Mr. Perozzo put together the new scaffold, okay? That he didn't bring a scaffold from upstairs, that he put together the scaffold that was new. That when he came back in, it was a scaffold on the floor that was partially disassembled. He also testified.
So your adversary cites to a number of cases where courts have said that the improper rigging of scaffolds and safety devices, and if there's an accident, we generally don't find that the plaintiff is the sole proximate cause, because that goes to comparative negligence.
Well, but there's more recent Court of Appeals decisions, like, for instance, Bondscar versus American Multi-Seminar, which upheld ultimately the decision of the appellate court that said that the plaintiff's own acts and omissions, particularly as to the ladder's positioning, and plaintiff's failure to check the ladder's locking mechanism were the sole proximate cause of his injury. So I suggest that it is a possible omission, that he did fail to lock out the pins, and that there's a plausible view of the evidence based upon all the testimony in this case and the different versions that a jury could believe could go either way. And that's all that's necessary to defeat a motion for summary judgment. Thank you.
Thank you. Santos versus Monondoc Construction.
David. Yours?
Good afternoon. Brian Kalman, London Fisher, for the defendant appellant, Monondoc. This case is one that is at least a tribal issue of fact.
Well, counsel, I want to just ask you about the expert affidavit that was submitted, which I believe might be your basis for the question of fact. It was the scaffold that the expert inspected was done 3.5 years after the plaintiff's accident, correct?
The answer is correct that it's 3.5 years after the accident. What is not correct is that the basis for the summary judgment tribal issue of fact is Jim Spence's testimony. Jim Spence, at length, testified in detail that in order for the platform to be in place, for the plaintiff to stand on it, whether he says 5 minutes, whether he says 30 minutes, or whether he says 45 minutes, and the plaintiff on page 7 of his appellate brief concedes that it was 30 minutes standing on the platform can't, because as soon as you put any pressure whatsoever, it would have fallen right through. So it had to have been supported properly
Counsel,
if he stood on it.
Wasn't Mr. Spence's testimony based on, in part, on that accident report that he did, which he gleaned from information provided by the site safety manager, Mr. Mitchell, and Miguel, the tempo foreman? He said, I wrote down what they said to me.
Correct. But what Mr. Spence did is he went to the accident scene, he sees the scaffold, he's familiar with the scaffold, he knows how it works. When you go to the plaintiff's testimony, which he says he stood on the platform for whether it's 5 minutes, 30 minutes, 45 minutes, the way the scaffold works, you can't stand on it for a minute. According to Spence, taking the expert out of the equation, even if we take it out, Spence, who has his OSHA 30, gets it renewed every 5 years, has lots of experience, and the plaintiffs don't refute, it sits in there nicely. He couldn't have fallen through if he stepped on it 5 minutes, 30 minutes, 45 minutes. So
I'm sorry, am I to understand that Mr. Spence, when he testified, he based his testimony based upon what people had told him, not his own inspection.
He actually went up there, and if you go to record site 389, he knows how the platform is attached. 398 and 410 knows that the scaffold platform and the scaffold...
At the record at 368, doesn't he say that he wrote down exactly what they said to me? I fill out those reports, I write exactly what people tell me. Wouldn't that indicate that he got his information not personally, but from someone?
No, it would actually say he's very thorough. He just doesn't go up to the accident scene, but what he does is he questions people. Because the accident scene may not tell you the whole picture.
Oh, that is a beautiful way of getting around hearsay. That's good.
No, I'm not actually going to hearsay. I'm actually going to what he personally did. Not the hearsay statements that was in the C2 report that Miguel translated, which is inadmissible hearsay, which I put in my brief, because that's not... When he goes up to the area, the scaffold, as plaintiff concedes in the photographs, not broken. Not one piece is broken. And if you take the plaintiff's own testimony, take everyone else's, I was standing on it for 5 minutes, 15 minutes, 30 minutes, 45 minutes, it can't happen. because Jim Spence, who's familiar with this scaffold, not the expert, went up there, it's not broken, there's no bent pieces, it's not warped, and the only way it works for a plaintiff to stand on it 5 minutes, 30 minutes, or 45 minutes is if it's sitting in the area. It's not misaligned, it's not put in, and the plaintiff says it fell right through the middle.
So, counsel,
The platform's not broken.
How does this square with Hernandez, where this court found that an unexpected collapse of a scaffold is a 241 violation?
Sure, because I'll go back to your decision in Breilmeyer against Legacy Yards, when there's actually conflicting testimony as to whether the accident happened or didn't, and there's issues of credibility. You're entitled to have a jury decide the issues of credibility. Plaintiff's story that I was standing on in 5 minutes, 30 minutes, or 45 minutes, when, according to Jim Spence, that's not possible. Where's Jim Spence correct that that's how it was? We're not saying, we're saying at the very least, it's a tribal issue of fact.
So you're saying that there's a timeline that as long as it doesn't collapse within the first
No, it's
5
physically
minutes,
impossible.
it's
If you look
okay.
at Jim Spence's testimony at 398 and you say, if you put it in the platform, you either stand on it.
I'm sorry.
It's in properly, right? That's what,
And you're talking about the expert, right?
No, I'm talking about Jim Spence, who's with Monadnock. If you go to page record site 390, you cannot stand on the platform for a few minutes and then fall because the platform has to be an exact fit in the slot. Pay record site 390 again. If the platform is not in the slot, you can't stand on the platform. So it's Jim Spence, not Kelly Scott, the expert, because I knew where the court was going to go with that. I'm going with Jim Spence, who was deposed at length.
And how does Mr. Spence know this?
He actually went, he's familiar with the scaffold, number one. He's on the site every day, went up later in the day after the accident, not relying solely on McGill, and he knows how the scaffold works. So plaintiff's version of I stood on it for 5 minutes, 30 minutes, or 45 minutes, it's not possible the way plaintiff said.
Well, essentially, you're saying the accident couldn't have occurred the way plaintiff says it.
And right, and a jury should decide whether the plaintiff's version of the story is correct or Jim Spence's version of the story is correct.
Counsel, we had a couple of these cases. I don't know if I'm confusing them or not. Was this also the case where there was testimony that when Spence went up there afterwards, that the scaffolding had obviously been moved?
There was some testimony that that the platform was off. It was no longer on there. It was potentially moved, questions, but we're not going into the placement of it. We're doing, can you physically stand on the platform for 5 minutes, 30 minutes, 45 minutes, as plaintiff testifies, or is that physically impossible, as Jim Spence testifies, and that is a triable issue of fact between the two stories, which the defendants are entitled a jury to decide who is credible. You can't just discount Spence as being lacking credibility whatsoever because he did have personal knowledge.
And Spence's expertise in terms of standing on the scaffolds and how long you can stand, et cetera, that's based upon his knowledge of the scaffold and his working with the scaffold?
Correct. He testified at length that he's been in the business a long time. He has his OSHA 30. He renews it every 5 years. And this is a guy, he's not a hired expert. This is a guy that does this for a living. And I know, based upon...
Who's an employee who's a defendant's employee, right?
No, yes, Monadnock's employee.
Yeah.
But there should be just a jury should gauge them both, weigh the
wood
testimony.
break? Did the wood break?
Sorry about that, the red light.
Sorry. Did the wood break?
No, the wood did not break.
So,
and he was asked at length, did it break? No. Was it warped? No. Was the metal bent on the side? And then the plaintiff's counsel goes, well, what if you took a vise to it? Could you bend it? There's no bent metal. He's like, but not this one. This is not, when I saw the platform, it's not bent. The wood's not warped. It's not broken. Now, if it was broken in the middle, I see a different story. Then I see the cases that Hernandez and everything else that the court is talking about. This is not that situation. This is a situation where Jim Spence says it couldn't have happened the way plaintiff said. Plaintiff says it happened one way. Spence said it couldn't. It's just a tribal issue of fact. Thank you.
Good afternoon, Your Honors. Excuse me, Jonathan Dax, representing the plaintiff.
Counsel, your opposing counsel seems to argue that this case rests on the credibility between plaintiff and Mr. Spence, and not necessarily to follow the line of cases where we say where the scaffold collapses or breaks, that it is in fact a 240 violation. Where should we go with this?
Well, there's multiple problems with that argument. First of all, I think it needs to be commented upon how quickly and easily counsel has thrown their expert into the background, because, well, we know why. As far as Mr. Spence, reliance upon his testimony is misplaced. First of all, he didn't say half the things that counsel said he said. He said nothing whatsoever about his familiarity with this particular scaffold. He testified he didn't know who assembled it. The evidence is that it was already assembled. He is an employee.
What about the primary point is that if the slots are in their designated, or the planks are in their designated slots, that the scaffold can't collapse. Therefore, the accident didn't occur or couldn't have occurred the way your client explained in his EBT, because the wood itself was fine.
What Mr. Spence said over and over, the same as the expert said over and over, is that if this scaffold and platform were assembled correctly, properly, safely, whatever word you want to use, this accident could not have happened. Well, I'm very happy with that, because to me that means that the fact that the accident happened means that it was not assembled properly, safely.
But they do go one step further. They
Right.
say that we know, they're arguing that it must have been assembled properly because he was able to stand on it for 45 minutes.
Which simply means we don't know why it collapsed. It's one of those inexplicable collapses that this court has dealt with in numerous occasions. If there is no explanation that anybody can point to for why it collapsed, then it was defective. And there's no dispute about, I can't dispute that he was standing on the scaffold before he fell. Of course he was. It's also testimony that he actually moved the scaffold slightly and fell 5 minutes after that. But I'm not going to say you could stand on a improperly built scaffold for 5 minutes, but you can't stand on it for or you could stand on it for 5 seconds, but you can't stand on it for 5 minutes. That's the whole point of this. You can stand on it, and it shouldn't make you fall. Regardless of how that happened, regardless of who can explain how that happened, Mr. Spence did not testify that all of these things were appropriate. He was saying it's kind of backwards logic. I don't know if the word is syllogism or false syllogism, but he's saying that we know that this had to be an appropriately built and provided scaffold because he was able to stand on it, ignoring the fact that at some point thereafter he fell. What's most interesting, he got rid of the expert.
What they're suggesting is that the accident actually didn't occur.
Yeah, but there's no basis for that whatsoever. All the evidence in the record shows that the accident did occur.
Well, the platform didn't break, right?
No, but the platform was on the floor when anybody got a look at it. There's no reason why it had to be on the floor if he jumped off the scaffold or tripped off the scaffold or did anything else. He reported what happened within 25 minutes of the accident. There's an accident report in which Mr. Spence himself says that there was not proper placement of the platform on the scaffold. He wants you to believe that that language was from Miguel or Eric or whoever told him about it, but if the way I read that statement is he recites what he was told by others, he then says, this is what I was told by others, and then he says the conclusion, which maybe he learned from going up to look at the scaffold that had fallen, the platform that had fallen, and he says it was not properly placed. He himself says that. He himself also admits in his testimony that if there was a problem with the placement of the platform in any way, of course it could cause a fall. We know the plaintiff moved around on the scaffold, so there could have been a weak spot that could have caused him to fall when he stepped on it, at that point 5 minutes before he fell. And we also know from the expert's testimony, I don't want to let him go too fast and too easily, because we also know, I just lost my thought, that the, shoot, I'm sorry. We also know, this was going to be a good one. This was going to be my denouement, and I was going to walk off.
Oh, well.
We also know I'm sorry. Thank you for being patient with me. I am the last one to speak.
You're going to say that it was properly, if it was properly installed, the platform would not have fallen. That's one thing the expert did say.
Right, just like Spence says that. But it's illogical, because if you can't say that it was safe because he didn't fall when he immediately stepped on it, when it did fall when he stepped on it in some other point or later.
And also there's evidence, in fact, that the platform is not on the Baker scaffold, correct?
Oh, I know what I wanted to say. The expert's affidavit at no point, this is really interesting and important, at no point says, other than measuring the scaffold itself, the metal part of the scaffold frame, he doesn't say he examined it in any way or found that it was tight or that was loose, or there are a lot of reasons that have nothing to do with the platform and how it was put into the seat, as they call it, that could have caused or contributed to this falling into the middle of the.
I thought he examined it 3 years later.
Well, besides that, and there was no.
I thought he examined it 3 years later, and also he wasn't sure. We don't know whether that's the same scaffolding or not.
It's 3.5 years later.
Yeah.
We don't know. There's no evidence to show that it's the same scaffold. In fact, the pictures show that maybe it wasn't. And there's certainly no. Most importantly, of the three elements here, is that we have no idea of what condition. That the condition that the expert saw when he saw it was the same as it was before, and there's no indication of the chain of custody of this device. There was a lot of mystery as to where it was hiding and who was hiding it, and it was hidden from the plaintiff and not told so that the plaintiff could do their own examination.
Thank you.
There's a lot here.
There's a lot. Thank you.
Thank you very much. Thank you for your patience when my brain went out.
The plaintiff's counsel wants to go back to the expert repeatedly, even though he said we shouldn't pay attention. I'm going back.
But counsel, so what I gleaned from the argument essentially is that it's undisputed, the platform was down. So how is the platform down?
I can't explain why there's a piece later on. The platform is down. It's not, believe it or not, it's not in the middle where plaintiff testified it was. If you believe plaintiff's story, which adds more credibility why it should be in front of a jury, is that he fell flat forward. But it's not in between the scaffold poles. So your honors make a great point. If it fell flat down, just like the plaintiff said, you would expect it to be right below the scaffold, but it's not.
But I thought the scaffold was moved. There was testimony that the scaffold was moved, right?
But there's no testimony, there's no proof. If we can't leave common sense, we can't forget our common sense. If you believe plaintiff's story, it would have fallen down, which Jim Spence says it can't happen by standing 5, 30, or 45 minutes. You can't do that. That's one thing we can't leave our common sense out. You would expect the platform to be right below the scaffold platform. That's not there. The only pictures you have are with the plaintiff's taking it when the platform is leaning up against the wall, leaning up against something else. And I just want to resolve the court of any issues that the defendants hid the scaffold from view. The testimony is very plain. We didn't own the scaffold. Tempo owned the scaffold. Plaintiff's counsel could have called Tempo and go, hey, by the way, can we take a look at the scaffold? I find it a little odd, as he shot the arrow to me saying we hid it from him. Why didn't he take a look at it? Because they know it can't fall through.
Does the record reflect anything concerning the viability of the, I'm going to call it the lip that held the wood?
The pictures are in there. There's nothing wrong with the lip, because if there's anything
No, not that you say that. Does anybody on
No,
your side?
nobody says there's anything wrong with the lip.
Does anybody comment that the lip was fine?
Nobody says that there's any problems. In fact, plaintiff testifies the scaffold's not broken. So if you actually go, record site 149, plaintiff testified that he did not believe the scaffold broke. There's nothing broken. This is not a typical case where you have something broken, a piece of wood broken, a piece of metal broken. This is an accident. Jim Spence, plaintiff, let's have a jury decide.
Thank you very much.
Thank you very much, Your Honors. Thank you. Have a good one.
good lawyer. Yeah, of course. You wrote good briefs. Oh, no, I think you had bad luck in the case before. Baker scaffold case. Yeah, of course.